back to winning isn't easy. What you need to know about the quirky terms of employment separation agreements and elimination periods in an ERISA disability insurance claim. Now, I'll tell you, ERISA is complicated enough, but when you throw in an separation agreement, that can really mess things up. What do I mean? Well, many ERISA disability insurance policies or plans require that the policyholder or plan beneficiary satisfy an elimination period before benefits are paid. And you have to be disabled for a period of time to qualify. In other words, if you aren't disabled for the right amount of time, you don't satisfy the elimination period, so no benefits are payable. Unfortunately, what I see in employers' termination agreements is that they ask the policyholder or plan beneficiary, the employee, to sign a separation agreement. And what's in that separation agreement can destroy the ability to file the claim and to win that claim. So what's the deadliest clause in that separation agreement? It's one in which you give up the right to any vested benefits arising under an ERISA policy or plan. But what happens if you are a policyholder or a plan beneficiary and you haven't yet satisfied the elimination period? So let me give you an example because this can be a little complicated. Let's say that you last worked in February of 2023 and your policy has a 180-day elimination period. The date of the proposed employment termination is less than 180 days after you've last worked. Now, you're disabled under the terms of the policy, but you haven't applied for long-term disability benefits. When the employer dangles that separation agreement in front of you for your signature, what should you do? Well, the first thing you should do is to tell the employer that you want to have that separation agreement reviewed and that you're not going to be pressured into signing the agreement immediately. If they're pressuring you, that tells you that there's something in there that is going to ultimately screw you to the benefit of your employer. Now, next, you should be consulting with an experienced ERISA disability attorney for assistance in immediately filing an application for your short or long-term disability benefits. And thirdly, the employee, you, and the ERISA disability attorney should draft a clear carve-out provision in any release that provides for eligibility for ERISA disability benefits, including those claimed or unclaimed, vested or unvested, as of the date of the separation agreement. In other words, you don't want to give it up. And I don't like the word vested because there might be a fight as to whether or not the benefit period had in fact vested and whether or not you remain disabled during the elimination period. Now, if the employer is going to object to changes in the separation agreement, it might then be time to bring in another attorney, an employment attorney, who will consult with the employer and their attorney so that they can hash out the language in consultation, of course, with the ERISA disability attorney. There are many times in this instance that I will bring in my own employment attorney that's hired by my client, and that employment attorney and I are working in concert to try to get an agreement with the employer to amend the provision of a separation agreement. Why? Because the disability carrier is going to look at that separation agreement and see whether or not you've given up your right to ERISA benefits. And it's really easy, an easy win for an ERISA disability carrier or plan to deny a claim on the basis that you gave up your rights to file a claim by the terms of the separation agreement. So can you potentially appeal if that happens? Well, the answer is yes. There has to send you a detailed reason for the denial or termination of benefits. And potentially you should consider filing an appeal. But I will tell you, in the situation where we're dealing with the elimination period, the ship has already sailed because you can't go back and cure the elimination period issue. You either are disabled or not disabled. Either you have coverage or you don't have coverage. So I really think that it's a smart move to consult with an ERISA attorney and potentially an employment attorney before you are signing any kind of release or termination of employment, because it just have an adverse impact on your claim. Got it? Let's take a break.